Now, 2 years after the 2023 presidential election and following the end of the period of petitions against the results of that ballot, a new report has emerged that collates all the cases that ended up at the tribunals, the Court of Appeal and the Supreme Court. It's called From Ballots to the Courts by the Policy and Legal Advocacy Center, or PLAC, and in addition to documenting all the cases, the report provides analysis of the decisions that were reached and how they were arrived at in order to give judges as well as lawyers the background and the precedents that can guide them in future election petitions and also help to enrich upcoming adjudication processes, to quote one of the authors. So what more have we learned about that 2023 ballot as a result of this report? Well, for all this, I'm joined now in the studio by one of the authors, the one I quoted, the constitutional lawyer, human rights advocate, and executive director of the Policy and Legal Advocacy Center, or PLAC, Clement Nwankwo, who was the original convener of the Civil Society Situation Room and is a well-known advocate of electoral reform in Nigeria. Thank you very much indeed for coming in. Great to see you.
Thanks, me too, Charles.
What is the overall objective of this report?
One is to provide a compendium of what happened in the courts arising from the elections of 2023, provide a repository where you would document, you would see all the cases that went to court, and there were more than 1,700 of those records that we compiled, spanning nearly 100.
On all levels?
At all levels.
Yeah.
And more than 100,000 pages of court documents
That's
and papers. Yes. We worked on this over a very long period. And the purpose really is for us to see what happened in the courts. A lot of times people reach conclusions without evidence. We have reported every single case. We have put them into a volume, a hard copy volume. But beyond the hard copy volume, we've also created a repository of this, an online repository of this, and this can be found online.
So you can always refer to it very quickly.
It can always be referred to. It would be there for posterity, and people can see that. We scoured through every single document we could find, and the good thing and positive thing was that the courts gave us official permission to do so. The president of the Court of Appeal was quite helpful. The Supreme Court level as well, the registry was quite helpful. And I think what this has done for Nigeria, for lawyers, for judges, for litigants, for possible candidates in next elections, is that they can see the basis of why they could go to court or not. Sadly, when you look at all of the cases that were filed, more than 90% of the cases at the Court of Appeal level failed. And when you look at the records from the tribunals, a near amount of percentages as well failed. And several reasons are given for this failure in terms of why and how the courts reached the conclusion that they reached. The election petition, like I said, tribunals, 89%, 88%, nearly 90% of failure of the petitions.
But why such a high percentage of failure? Is that because lawyers didn't understand what to do, the law, how to file, and so on? Or was there something, I mean, was it the judges themselves who were either, I don't know, not competent or not, doing all kinds of, because I mean, in politics, most people think there's something underhanded going on.
Yeah, I think the word to use would be a potpourri of reasons. One is that there are jurisdictional issues that arises. When a case is taken to court, does the court have jurisdiction? Did the tribunal have jurisdiction with respect to a case? For example, you file a pre-election matter before the court, and the court is saying, look, we are set up to adjudicate on the issue of the election itself and how it was conducted, not on how the primaries were conducted.
But I mean, don't the lawyers know this? Well, I guess it depends on the lawyer.
I think it depends on the lawyer,
Yeah.
and sometimes also the tribunals. And but the courts have been quite consistent. And what is really very important is also
Right.
that the courts system, before even the elections were conducted, the Court of Appeal set up these tribunals. They were trained, and you know, at Policy and Legal Advocacy Center, PLAC, we were involved with supporting that training session for judges. So a lot of the judges got very good guidance on what to do. Unfortunately, of course, not everybody took their lessons quite seriously. So some
They
of
failed their exams, did they?
well, the exams is actually their adjudication of the cases,
Right.
and we did see quite a few cases where the judges give decisions that you rightly would ask questions. How did these judges come about this decision? But jurisdictional issues, the issue of procedure, for instance, if a lawyer does not comply with the procedure for filing a case, if a case is filed out of time, if before a case is concluded, time runs out. As you know, the Constitution is quite clear on the number of days that an election petition could run for. So several of these issues, burden of proof, the whole idea that an election is presumed to be regular, and then you have the burden of proof and the onerous challenge of proving a case. Unfortunately, our Electoral Act requires that when a case goes to court, INEC, which conducts the election, is a party to the petition. And so INEC goes to court defending the election it has conducted.
Yes.
Whereas in reality, or for the purpose of justice, INEC should be neutral, non-partisan.
Is that where electoral reform comes in? Because I know you're a big advocate of it, and I'm wondering how much that played into this report that you produced.
Oh, quite a lot, because we did have recommendations about electoral reform at the conclusion of this. This is not a report that is produced for the purpose of criticism.
Sure.
This is a report that is produced for everyone to see what has happened with the courts, with the petition tribunals, even up to the Supreme Court, and suggestions on what to do to improve this. And we're happy that the National Assembly Committee on the committees, because this is both Senate and House now, are taking very seriously some of the proposals contained in this report. And we're hoping that as the National Assembly goes to the further amendments to the Electoral Act, or perhaps even a reenactment of a new Electoral Act, that these recommendations will prove quite useful.
But of course, you talked about the number, I mean, absolute, huge volume of cases that you had to go through, and I commend you, a prodigious effort. But I mean, most people would be thinking of the presidential election and saying, right, okay, you examined obviously the cases that were filed by Peter Obi and Atiku Abubakar and all the rest of it. And what sort of conclusions did you draw from assessing those cases?
I think that when you challenge an election petition at the presidential level, the burden is huge. First of all, the courts are demanding that certain types of evidences be produced. And those types of evidences include that if you say that an election was badly conducted, or that the results from a particular polling unit did not reflect the actual count, apart from the oral evidence of this or documentary evidence of this, you have to bring witnesses. And that's why the whole issue of parties having their agents at polling units. And as you know, it's nearly 200,000 polling units across the country. Did the parties who were challenging this election have agents in these polling units? All of them? Were they all deposed into sworn affidavits, and did they all show up at the tribunal? The answer is no. Because the courts have adopted the view that the evidences that you have must be supported by oral evidence. And it would seem to me that that would be a major hurdle that the parties that challenge the presidential elections couldn't cross with the courts. And it's a question How do we then go forward?
Right, because I was going to ask you, in that context, what sort of recommendations would you have made about that kind of, at that level?
I think that we must commend INEC, and I know that a lot of us have very strong criticisms of INEC, but we must commend INEC that it's been able to outline different innovations. The challenge with the 2023 elections was that those innovations failed. To use the famous word, there was a glitch. But there
were a number of glitches.
A number of glitches, of course. But the major glitch was in the IREF portal.
Indeed.
And the purpose of the IREF, and again, I must say, commending INEC, but the purpose of that was we take the result sheets from the polling units, we upload it. And INEC failed to do this, contrary to its own guidelines, which was the major challenge. Now, what do we do with that? What do we do with the BVAS, for instance, and the results coming from that, and the failure to upload? It means that if we have come this far with innovations, we must ensure that those innovations, for which millions or billions of naira was spent on, must not waste.
Absolutely.
So it must become mandatory that results are uploaded on the IREF, that those results are certified as uploaded on the IREF, and then you do not need to call 200,000 witnesses to come to court.
Absolutely.
Once it's certified and up there, the courts can, by the press of a button,
see what is there and do their own assessment.
So those are the innovations that must be enforced as we go to 2027, because we can't waste that amount of money and still come. It's actually a very serious offense.
It is.
For you to spend such billions of naira and very perfunctorily say that there was a glitch. So that's something that the Electoral Act, as we go forward, needs to see what should be done. Secondly, when you look at the BVAS that was used, after the first elections in 2023, the question then arose, and this was the national elections. There was going to be the state level elections, which was the governorship and state assembly elections, and other elections that couldn't conclude. And INEC proceeded with those elections, but stated that it had wiped off the information on the BVAS machines to enable them use it for the
other ones.
Following elections.
Right. So there must be a storage system.
There must be a storage system.
At least for a period of time.
Yes, there must be a storage system.
For the litigation process to be exhausted.
Exactly. But there's also the proposition that elections across board should be conducted on the same day. And I think there's wide support for this because it's only 2 levels of election, which if you put together is 5 different positions: the president, the governor, the National Assembly, the State House of Assembly.
Yeah,
so in reality, it's the executive and legislative elections. And I do not see how it is impossible in this country that these elections cannot hold on the same day.
Well, I would imagine that your report, I mean, the weight of the evidence that you've collected and the analysis that you've done would certainly support that argument if it were, and I would imagine that the National Assembly were probably one of the stakeholders in this report that you produced, as well as the Electoral Commission and so on. So they have you've got their buy-in to some extent.
Well, this is independent of any of the
I understand
stakeholders,
that, but I mean,
the recommendations...
you would have had their cooperation.
We've had the cooperation of the courts in doing this, and I must say that the courts thought it was useful for this to happen, because it would be the first time that you would have every election petition case reported. So everyone who has gone to court can see that. Going towards 2027, any lawyer who decides that they want to file a case on behalf of a client who has briefed them will need to read this report. We need to look at cases arising from previous exercises.
Absolutely.
In order to be able to make a sound judgment, first as to whether they should be filing a case or not, Secondly, what is it that the courts have looked at?
And of course, it'll help tremendously in unclogging the courts and getting rid of all the so many, because I mean, you mentioned so many cases that were thrown out because they were not supposed to be there in the first place.
A lot of cases were thrown out for different reasons, and you would know, and I hope that the proposals for amendment to the Electoral Act or enactment of a new Electoral Act will take into account several of the issues here, which is really what is the status of the BVAS, of the IRF voting portal, or of the issue that we've just talked about, which is the issue of witnesses. What kind of witnesses do you need? What is the burden of proof? Is it substantial non-compliance? What is the extent of compliance by INEC? And then the whole issue of INEC being a party to election petitions. Because INEC is listed as a respondent.
We've got 30 seconds,
as a respondent, it means that they go to court to defend both ill-organized elections and properly organized elections.
Absolutely.
If they are neutral in a case, then parties that complain that INEC is not able to give them the evidence that they need, is not able to give them certified documents, will also understand that INEC will understand that it has no reason to not be neutral with all the parties to a suit.
That's a very important point. And congratulations again. Skimmed through it. Very, very solid work.
Thank you.
But that's what we
Charles.
expect from you, isn't it?
Thank you so much.
Thank
Charles.
you very much indeed. Clement Nwankwo is a constitutional lawyer. He's one of the authors of that report. He's also a human rights advocate. He's the executive director of the Policy and Legal Advocacy Center at PLAC, and that's the group that produced the report. And he's also the original convener of the Civil Society Situation Room and is a well-known advocate of electoral reform in Nigeria. Good to see you. Thank you very much.
You too, Charles. Thank you.
That's it for this edition of Arise Prime Time. Join us again tomorrow. From me and the entire team here in Abuja, bye-bye and thank you for watching.